Mr. Duggal, Chief Executive, AI Law Hub, with us here on the broadcast. Many thanks for taking out the time, Mr. Duggal. This is the message only to Meta, or do you think this is a broader warning to all the big tech platforms operating in India? How are you looking at the developments and some of those top quotes from the top court? WhatsApp argues that users have consent to that policy, but under the Indian law, is consent valid if it's buried in a complex web of language and that most users can't understand? The court themselves said, I mean, an uneducated person in rural Bihar is also using WhatsApp, and we sitting here in the top echelons of society can't understand your policy. What is that person going to understand your policy about?
Clearly, what the Supreme Court has said is nothing but mirroring the hopes and aspirations of the people of India at large. Also, the kind of comments that come from the Supreme Court are nothing but indicative of one fundamental message that's loud and clear to all stakeholders, which is that if you have to operate in India, you will have to comply with Indian laws. You will have to respect Indian privacy, Indian fundamental rights under the Indian Constitution. And what the Supreme Court has said is nothing but also a mechanism to strengthen Indian cyber sovereignty. Why? Because when you are coming to India and you are making the data of Indians as guinea pigs for purposes of monetizing the same, it's time that the topmost court in the country comes in and says, you can't do that. Why? Because it could also prejudicially impact the enjoyment of cyber sovereignty, security and integrity of India. So it's something that was coming quite some time back, but this comments now coming from the Supreme Court.
So, Mr. Duggal, India has a data protection law, but I mean, it's not fully enforced yet. We still have to wait and find out what happens on the 9th of February when that interim order comes out. So today, help the viewers, help them understand what law is really protecting Indian WhatsApp users. It's such a huge market, about 850 million. Is it the competition law? Is it the constitutional privacy? Is it a mixture of both? Or do we need something more in terms of reform here?
Let me begin by giving you the not so good news, which is that Indian WhatsApp users are not at all protected in terms of having effective remedies under applicable law in India. Why? Because the Digital Personal Data Protection Act has not yet kicked in terms of implementation. Why? Because the Information Technology Act 2000 does not talk issues pertaining to protection of privacy. Why? Because the IT rules 2021 are relatively silent on what kind of remedies the users can have in the event their privacy is going to be violated. Yes, the grievance redressal mechanism dispute process is available, but we know for a given fact that even if you raise a dispute under the grievance redressal mechanism, the result is known to you at the time when you file it, that it's bound to be rejected, it's bound to be not accepted. Why? Because it's a de facto norm of the company that let them come up with as much data as possible. It's something like, it's like the gold heist that's taking place. They know India has not yet come up with strong laws. Let's try to collect as much data from Indians, from India, so that we can then keep on using them till eternity for purposes of monetization of the same. I think it's time that the government needs to come up with effective remedies to users. And the Supreme Court warning is nothing but a noise, a shout in that particular direction. And I think till such time you don't really strengthen the lay users of WhatsApp in terms of having effective remedies in the event their privacy gets violated, we are all beginning to continue to keep on seeing Indians and their data being used as guinea pig data.
Looks like a huge uphill battle, Mr. Duggal. I mean, awareness creation amongst 850 million users is a mammoth of a task, but